Good morning, and thank you all for coming. I'm Susan Kaplan, and I'm speaking. My title of my speech is The Infallible Victim and Unimpeachable Trauma, Fallacies and Bias in Title IX Tribunals. I am purposely creating some hyperbolic language because there is already so much hyperbole entrenched in this issue. We have accusers who enter into the tribunal with the mantle of victim, not even alleged victim, sometimes even survivor. There's a presumption that this survivor is suffering from trauma, not even garden variety emotional distress, which is a far more deflated term. I come to this, and I come to you from the trenches, so to speak, actually advising. I'm an attorney, but I can only rise to the role of advisor on campus for students who are accused. And as we just heard, I am the coach in the background for an 18-year-old, a 19-year-old to kind of manage this heavy burden. And, you know, no pun intended, but he's the accused. The burden actually should be on the accuser side, the burden of proof. But in fact, because of this infallibility that even Kathy spoke of, where there is no skepticism when it comes to the accuser, the burden automatically shifts to the accused, it seems. I come to this with some academic and feminist cred as well. Before I was an attorney, I was an English professor at VMI. I was female number 4 on the faculty back in the day when it was an all-male corps. I was one of the first, I headed a department, the honor college, as a woman there. And I was probably one of the first faculty members, probably the first woman to visit a student in prison who had been arrested for date rape. That was, we're talking about the late 80s, early 90s. That was the world we were in then. Date rape, if you recall, that has kind of gone out the window and has been replaced by various waves of feminist campaigns where date rape kind of turned into rape is rape, which in and of itself was troublesome, kind of assuming, again, another kind of infallibility. Couple rape is rape with trust. If a woman says she was raped, we don't even need a tribunal. We don't need any adjudication. We just simply have a show trial, if even that. But that was seemingly the rhetorical ideal that followed the failures of date rape. By the way, the student at VMI, because of the honor program at VMI, just being accused of a felony, he was a goner. There was nothing back then. I remember going to visit him in the county jail with his homework, and then before it was due, he was gone. He was out of state, and that was that. So that stayed with me. It stayed with me all the way up till the point after becoming a lawyer and not even involved in these issues. A former colleague called me just recently, post 2011, the key year in all this, and said, Susan, please, I know you're a lawyer now, but I have a female student, and she was raped, and she needs your help. I said, well, I'm not a criminal attorney. I mean, what does she want my help for? You know, that we have a criminal justice system, go to the police. No, you don't understand. She got raped by a professor, and VMI is doing nothing about it. I said, well, why should VMI be doing anything about this? I mean, this is how, I mean, my knee-jerk lawyer chops wasn't even being triggered by this. I said, well, why doesn't she just go to the police? Why are you coming to me? He talked me into talking to her. I heard the story. It honestly sounded like something rising to familiar criminal territory, not this inflated criminalization that we're dealing with here, but it might have occurred to her. And I said to her, why don't you go to the police? It was as if I was speaking gibberish. I mean, it was just like, no, the issue is VMI. And I said, well, you know, I don't know what I can do for you, really. And I started investigating this, and now I find myself actually representing students accused. So we come into this situation with these presumptions, which is very counter to what you would find in the civil arena of the courtroom, where even, as I already mentioned, garden variety emotional distress. That is emotional distress that isn't verifiable medically. It's just sort of the plaintiff, and the plaintiff still has the burden of proof. The plaintiff is in the same role as the accused, or we can make that parallel comparison, is saying, yeah, I didn't go to a psychiatrist. I'm sorry, I can't afford a psychiatrist, perhaps, but which is usually the case. But believe me, when I lost my job, when my neighbor killed my dog, when you know, whatever, all kinds of problems that arise, I couldn't sleep. I felt so hopeless. My hair started falling out. I've had cramps nonstop for the past 6 to 8 months. You know, people recognize that as within the realm of possibility for emotive responses to stress. But here's the rub. Who knows who you are? Who knows what other stress factors in your life? You still have to verify. You have to be able to go under cross-examination that has already been recommended by the preceding speaker and say, well, no, I've never had cramps before. My hair has always been full and lustrous until this happened. I've been the model of health. Or yes, of course, I've had stress up and down, but you know, it's been 2 years since I ever had to take a sleeping pill or whatever. You try to, even without medical verification, establish where you are emotionally. In the Title IX tribunal, if she's crying, she's not lying. And you know, it is so easy to come in and say, oh, let me also clarify. I think a lot of us here are familiar with the context of complaints that are being asserted here. There is sort of a continuum. I'm dealing with the kind of complaints that Janet Haley, in her Harvard Review article in February of 2015, Trading the Megaphone for the Gavel in Title IX, identifies as the hard cases. They're the hard cases, but they're the ones that are most familiar to us. They're the most pedestrian. These are the interpersonal cases where there might be an ongoing relationship between the parties, or even if it's informal and casual, there is a pattern of consent leading into the encounter. There might even be post-relationship, post-event relationship issues going on. There's usually alcohol involved, and there's a lot of ambiguity about what happened. There's a lot of gray area working on the continuum of seduction to force, if you will. These are the hard cases, as Ms. Haley talks about them. The easy cases are the ones where the Mickey is put in the drink and the victim is knocked out and raped and all that. That's easy in terms of we know what to do with that. We have a mechanism. It's these gray area cases that are hard. In these gray area cases that are hard, there is a, boy, I'm towards the end too, without hardly saying anything I went to say. There is the victim comes in and declares what is called trauma, her survivorship, but keep in mind what the context was. A mostly consensual situation fueled by alcohol. She has a choppy notion of what kind of happened, but you know, it didn't. For various reasons, it's hard to put a finger on. And she's claiming trauma. The trauma carries into the first thing it does is it is a punitive response without any pre-hearing. Usually the student, the accused, winds up with some kind of, quote, interim measure, which can be anything from a no-contact order to absolute probation and removed from school, removed from his dorm, with no challenge to whether anything happened at all. To sum up, I just want to carry this through. I had a student who was just found not responsible for the claims against him in a tribunal. However, part of the claims against him was stalking. However, in the final report, the panel, in their finding of fact that there was no stalking, nevertheless tips its hat to the accused and kind of apologizes. And they say, though the panel is sympathetic to the accuser's experience and appreciate her distress, we find that the student didn't stalk. Well, then where's the distress coming from? To sum it up, even though he was found not responsible for anything, and it was also sexual assault, there was a whole panoply of things, he's still under a no-contact order so long as he remains on campus with respect to the accused. He still has stink on him. There is no innocence here. So if you come in with a presumption, you wind up with a presumption of victimhood. What you wind up with, what you're really dealing with, is a presumption of guilt. He never can achieve innocence under this system. Even if he's found not responsible, they can't find a single fact against him. We say, well, listen, even under preponderance of evidence, we couldn't find you faulty of anything, no contact order. Okay, so that's what we're dealing with. Thank you. My next speaker.